May it please the Court. Good morning, Your Honors. My name is Ken Walton, and I represent Cosentini Associates, one of the appellees in this matter. Cosentini was the electrical designer on the project, and the only claim that we are here today to discuss is a contribution relative to Cosentini, is a contribution claim. The time I'm going to split the 15 minutes with my brother Matt O'Leary, who represents the architectural firm of Cambridge 7 Associates. I know the Court is familiar with the underlying facts. This case settled with other parties for a total of $3 million, and now two of the co-defendants are attempting to pursue their contribution claims against my client Cosentini and against the architectural firm of Cambridge 7.
I'm sorry. Implicit in what you're saying is insofar as the appeals court found the indemnification, I know this isn't you, it's Cambridge 7, but insofar as the appeals court found indemnification would go forward, we're not getting there. All we're focusing on for both of these, part of this team, is the contribution.
No, thank you, Justice Watson, and I want to be clear on that point. The indemnity claim, the contractual indemnity claim, is between Hilton, the project owner, and Cambridge 7.
Right. So you're not saying Cambridge 7 is giving that up? It's
no,
no. You, Cosentini, is only talking about contribution.
That's correct,
okay.
Your Honor. And we spoke among counsel before, just because we didn't want to quibble over something such as that. The claims that the two co-defendants are pursuing against my client are contribution only. It's contribution and contractual indemnification against the architect. So my comments are focused, obviously, on the contribution claim. And there's actually four independent bases for why we believe that claim cannot stand, and why we also believe that the trial judge, Justice Kratzley, got it right in granting his motion for our motion for summary judgment. First, as an initial matter, under Chapter 231B, the statute is clear that in order to pursue a contribution claim, the party, you must be able to establish that there's joint liability in tort. And what happened below was the court granted summary judgment dismissing the claims against Cosentini and Cambridge 7, the plaintiff's claims, and the contribution claims. That decision was never appealed. The final judgment that we obtained dismissing the plaintiff's claims remains true today. The plaintiff never appealed. And there's certainly a mechanism, a procedural mechanism, for standing in the shoes of the plaintiffs in pursuing that claim. The plaintiffs could have taken an assignment of rights under a settlement agreement and could be here today standing in the shoes of the plaintiffs, saying that the entry of summary judgment was incorrect. And that is not what occurred. Instead, the co-defendants executed a standard release wherein they reserved the right to pursue their contribution and indemnity claims, and that's what we're here today to argue. But that procedural mistake is imperative to our argument as to why the contribution claims cannot stand.
So you don't even need to reach whether Judge Kratzley was right or wrong.
That's correct, Your Honor. And I think that finding is very consistent with cases that we cite throughout our briefs that were issued by this court and that are long-standing law in the Commonwealth. The McGrath case, the Barabee case, the O'Mara case, the Dighton case, all of those cases, admittedly in different procedural contexts, have an underlying assumption to it. In order to pursue a contribution claim, first you have to establish that there would be joint liability and tort to the plaintiff. That can't be done here.
Well, the problem, I guess, is that in some of these cases, there's language, just take McGrath, there's language about if the plaintiff could have been liable, if the defendant from whom you are seeking contribution could have been liable to the plaintiff. So the problem, I mean, obviously, if you take the appeals court's ruling with respect to the substance of negligence, could have been liable, but you're saying you don't even need to go there because whether could have been or not, the judgment on the books is that they weren't.
That's exactly what I'm saying, Your Honor. And that is at the core of our argument on appeal.
Does it make a difference in your case that you got judgment on the merits as to liability as opposed to some procedural issue?
Yes, Your Honor. And that's absolutely the question, and I expect you'll hear that from the other side when they stand to argue. That they'll take those cases that I just cited, long-standing Supreme Judicial Court cases in this, and they'll distinguish them one by one. They'll say this case involved a statute, this case involved immunity. But I actually go back to the exact words of both the statute itself, which talks about joint liability and tort, and the McGrath case, which says, and actually the Barabee case, which says, the right of contribution is derived from plaintiff's primary cause of action and is not recoverable from a third party against whom the plaintiff has no cause of action. So that distinction, which is certainly briefed in the papers, and I certainly expect to hear it from the other side, it's not carved out with that level of specificity as to say this exception only applies to statutes or other things. The crux of the argument is, unless you can show liability to the plaintiff, which can't be shown in this case because of the summary judgment order, there cannot be joint liability in tort. So getting back to Justice Botsford's point, that's the first argument that we have, is that absent pursuit of the appeal on behalf of the plaintiff, absent vacation of the Rule 58 judgment that was entered on appeal, either to the appeals court or this court, they cannot establish right to contribution under Chapter 231B. Now, turning to the second argument, which is the merits of Justice Cratsley's decision below. It was a very important decision, and it was grounded in controlling legal standards and controlling standards in the construction industry. 2.1.9 states specifically that the designer shall not be responsible for the contractor's failure to carry out work in accordance with the construction contract, and shall not have control or charge of the acts or omissions of the contractor. The reason that provision is so important, Your Honors, is that it defines what designers can and cannot do on the project. They can write letters to a contractor. They can't force a contractor to do anything. And that's what Justice Cratsley found. He said the ultimate responsibility to do what the engineer tells you to do rests with the contractor, the owner, the general contractor, the subcontractor, the inspector, none of whom we had control over on the project.
It would help if you told the owner of the problem.
And, Your Honor, we did actually, in a letter. We are bound by our contractual line. In the appendix, A707, Cosentini wrote that letter, and they said you should put these signs in.
No, I meant after that, when it wasn't there.
After that letter. Yes, Your Honor. Your Honor, my time is up, so I will turn the floor over and rest on my brief for the remaining arguments.
Thank you.
Thank you.
Chief Justice, Associate Justices, may it please the Court. My name is Matthew O'Leary, and I represent Cambridge 7 Associates Incorporated. And I just want to follow up on the first argument that Mr. Walton raised, and that's the contribution statute itself. And I'll draw your attention to Chapter 231B, Section 3F, which I think applies to this situation. It states that where a judgment enters on a plaintiff's claim, that judgment is binding as to the defendants on their contribution, to determine their rights of contribution. So I think that applies directly here. Turning to the merits of the case, I want to point out before I start that we're asking that you affirm the award of summary judgment in favor of my client, as well as affirm the denial of a motion for reconsideration that was filed later. And that's important because there's two different standards of review for you to consider. On the summary judgment motion, you're looking at a de novo review, obviously. But on the motions for reconsideration, you're looking at an abuse of discretion standard. And that's important because one of the grounds that the trial court entered summary judgment in favor of Cambridge 7 was a lack of an expert witness. there was no expert testimony in the summary judgment record when the court ruled. The only time an expert came before the court was on a motion for reconsideration, and the court, in its discretion, decided to deny that motion for reconsideration for a number of reasons which had grounds in the record, including the fact that the expert that was disclosed didn't change anything. He didn't give an opinion on the standard of care. So for that reason, you should affirm the award of summary judgment.
Now, if we can, let's turn to the indemnification.
Sure.
And I gather that they're not seeking common law indemnification, they're seeking contractual indemnification.
That is correct, Your Honor.
Does the judgment do you any good as to that?
Yes, it does, Your Honor, because the contractual indemnification provision at issue here requires that Logan Hilton show that my client was negligent, that the damages suffered were caused by my client's negligence. So that negligence is precluded by that judgment. That judgment says you didn't have a duty to the plaintiff, so therefore they can't turn around and say, yes, you indeed did have a duty to the plaintiff.
Well, you certainly, the provision says if you were found to be negligent, I mean, if you were negligent, why can it not be that you were negligent with regard to Hilton in failing to provide Hilton with notice of this problem and saying to Hilton, you should not be paying the contractor because we've been telling them to put those signs up and they haven't done them?
Because the damage that Hilton is looking for here isn't the cost to put up those signs. They're looking for the money that they had paid for the plaintiff's injuries. So there's a distinction there that what they're claiming indemnification for is unrelated. It's a different set of damages.
No, but isn't, if you had given them the appropriate notice, they might have done something about it, and there wouldn't be these injuries.
In order, and this goes back to paragraph 2.1.9 of the contract, which says, and this has bearing on the negligence claim.
That has to do with who controls putting it up. It doesn't say anything about the responsibilities in its other sections, and I'm not going to remember the 2-point-whatevers, but that talk about what Justice Gaines is saying about giving notice of whether you should pay, giving notice of the every 2 weeks that this is going forward, the substantial completion, I mean, all those different times of notice when this was not remarked upon. If Hilton had known that, they might have done something.
Well, that is a bit of speculation, but it all goes back to what they're looking for in their claims here. They have to prove, and they admit in their brief, that we were negligent to the plaintiff, that our negligence caused the plaintiff's injuries. And we're saying that based on the contractual provisions that say it was not our responsibility to make sure that this mimic bus diagram was on there, that we cannot be liable to the plaintiff. Therefore, their contractual indemnification claim, they cannot prove it because they have to prove that we're liable to the plaintiff.
Now, is the liability of Hilton purely vicarious here?
Their liability is also, I believe, as an owner. The allegations were that they had allowed this particular situation to exist on their property for X number of years. It was years after the construction had happened. So it's as a property owner.
Including the period after after Hilton no longer retained your client?
Yes, Your Honor.
So the gist of what you're saying essentially is that the 9.1 and 9.4 make reference to negligent acts, errors, or omissions, and that the judgment of the court that there was no negligence by CSA is dispositive.
Yes, Your Honor.
Even though it's a contractual provision and not a common law identification.
Yes, Your Honor, and they still have to prove under that contractual provision that my client was negligent, and the court has already ruled that they weren't.
But if there was a basis, I guess I'm confused. Assume for the minute it was negligent not to provide at one or more of these various opportunities notice that indeed there was a problem here because this was part of the contract plans, was that the warnings or the bus mimic would be up there. and they weren't, assume that that was negligent on your part or Cosentini's part, why wouldn't that trigger indemnification?
It would trigger indemnification, Your Honor, to the extent that they're looking to get paid for the lack of that mimic bus diagram being on that switchgear, because that's what that
But they
provision
would
is.
have to prove, I appreciate the fact that they'd have to prove to somebody that the cause, a substantial contributing cause of what happened to Mr. LeBlanc was something that they were responsible for because they didn't take steps, that is, Hilton didn't take steps, having learned, or that was connected to the lack of notice. But if they did that, I guess I just don't understand why they're not connected.
I think my point is the observation and the reporting requirements are really solely to protect the owner so it gets something that, so it doesn't pay for something it didn't get. So the damage that would arise out of my client's failure to report that, if they had an obligation to do so, would be the only claims they would have on.
The cost of the signs? That's all?
Yes, Your Honor.
Well, we'll have to leave it there. Your time is up.
Thank
Thank
you.
you.
May it please the Court, my name is Curtis Carpenter from the firm of Morrison Mahoney, and I'm here today representing Logan Hilton in this case. It's the appellant. And as is noted by my brothers for the appellees, that the claims that Hilton is pursuing in this case is a contractual indemnity claim against Cambridge 7. However, it should also be noted by the indemnity language in the Cambridge 7 Hilton contract, Cambridge 7 is liable for indemnity to Hilton, not just for its own negligence, but also that of its consultants.
Could you just address the point just made?
That
all you could get from Cambridge 7 and Cosentini would be the cost of putting the signs up?
frankly, Your Honor, I think that's rather absurd. I mean, the language of the indemnity agreement makes clear that, true, we have to establish that either Cambridge 7 or its subcontractor, Cosentini, was negligence, and that negligence was a contributing factor in the death of Mr. LeBlanc. However, to suggest that the responsibilities that are detailed in the agreement between Cambridge 7 and Hilton were simply to ensure that we were paying for things that were done, it's not logical. It doesn't fit with the language. If you actually read the actual contract provisions we're speaking of here, I don't see any support of that, and I don't even feel that it's actually been argued at any point in this case to this date, through summary judgment, through reconsideration, through appeals court proceedings, and before this court in its briefs. I don't think that argument has been made to this date. Your Honors, this case is much simpler than the 2,000 pages of the record appendix and all the briefs would suggest. This case has always been about the fact that Cosentini knew that there was no bus diagram on the cabinets that were at issue in this case. They were aware of that fact. They put it in writing to the electrical contractor, but did not tell my client, Hilton, that this was an issue.
Assume you're right, though, but they say they've got a judgment, a final judgment. So how can they be held liable for contribution or for a finding of negligence necessary for identification when they can waive that final judgment and they say it's final?
Well, Your Honor, I mean, I'm going to leave the contribution issues to my brother for representing Broadway here
well,
for the most part, because I think the indemnity claim is our principal claim in this case. And I would just suggest, Your Honor, that the fact that the plaintiff didn't appeal the negligence claim and the fact that I did appeal the judgment on the indemnity claim are completely separate matters. The fact that I appealed the indemnity claim, I think, has preserved my rights quite adequately to suggest that the indemnity agreement should be enforced, and that the prerequisites to that are that there has to be a finding of negligence. I don't think it has to be a finding that there was negligence towards the plaintiff, and the plaintiff was the one who had to pursue that claim, I think I'm free on my own to pursue that for my client, as long as I can establish that there was actual negligence in this case.
For
And I
the
think
indem-
it's
for the
evident.
indemnity.
I'm sorry, Your
For
Honor.
the indemnity, that's all you're.
That's all I'm arguing at this point. I mean, we also take the position that we're entitled to contribution as well. However, these are mutually exclusive remedies, and the remedy that we're most vigorously pursuing at this point would be the contractual indemnity agreement with Cambridge 7. And I would just like, if I could, to hit on a couple of the points concerning the expert testimony, because that's been an issue throughout this, and the fact that the allegation is that we should have somehow put forth expert testimony at the time of trial. However, at the time of the summary judgment hearing. And I would suggest, Your Honors, that, number one, the duties in this case are defined by the contract. It is not a case in which we are suggesting that there was something inherently wrong in the design of the switchgear. If I was making such a claim, I would indeed need to present expert testimony. That's not what we're suggesting. We are suggesting is that the contract provided that these warning signs were going to be on this particular switchgear, and that Cambridge 7 and its sub-consultants had obligations under the contract to visit the site, make appropriate observations, and report them back to my client. Those obligations of oversight do not need any expert testimony to testify to. It's in black and white, right in the contract. Now, it may be argued, and my brother for Cambridge 7 has argued that, well, how often do you have to go to the site and visit? Does this mean regular visits? I mean, what are the observations they're required to make? But that's not beside the point, because we don't have to establish in this case that Cambridge 7 or Cosentini knew or should have known. They knew. We don't have to prove constructive knowledge. Possibly, if we were going to try to establish constructive knowledge, we might be required to have an expert come in and testify as to how often such visits to the site should have occurred, and what should have been observed, what should not have been observed. But in this particular case, and it's in the record appendix, and I believe 707-708, is the letter that establishes that Cosentini did, in fact, know.
Right, but the judge's point, I think, is that in terms of establishing what the standard of care is of the architect or its consultant, that you need an expert to help a fact finder ascertain whether the failure to inform the owner of everything constitutes a breach of the standard of care.
Well, I think the point that the appeals court makes is that with the inherent dangers of high voltage electricity are readily apparent to the lay members of the jury, for them to decide that such a thing as failing to put a life-size mimic bus drawing on 10 cabinets, that seems pretty obvious that, and I think the Parent versus Stone and Webster case supports that position, is that you don't really need an expert in a situation where something is so obvious that it's dangerous, has high voltage electricity. And finally, you don't, as argued in my brother's briefs for the appellees, that we somehow need an expert for causation. However, I think that one of the things that I do agree with Judge Kratzley's original decision is it's undisputed this accident was caused by the failure of proper signage to be installed on these cabinets. I think you don't need an expert for causation. I believe the duty is established by the contract, and they knew. They just knew. You don't have to prove how often they should have visited or when they should have visited. I just want to point out this one of the cases that's cited prominently in the Cambridge 7 brief is a case from 1990 from the Supreme Court of Alabama, the Watson Rutland Architects, Inc. case. They cite it prominently in their brief, and I just want to point to the Court's attention to how much this case supports Hilton's position in this case. And the Court writes, although the contract here clearly made the architect's inspection a limited one, We cannot hold that it absolved the architect from all possible liability or relieved it from a duty to perform reasonably the limited contractual duties that it agreed to undertake. Otherwise, the school board, which was the plaintiff in that case, argues that the owner would have bought nothing from the architect. While the agreement may have absolved the architect of liability for any negligent acts or omissions of the contractor or subcontractor, it did not absolve the architect of liability arising out of their own failure to inspect reasonable, nor could the architect close its eyes to the construction site and not engage in any inspection process and then disclaim liability for construction defects that most perfunctory monitoring would have prevented, or, and here's the key, or failed to advise the owner of a known failure of the contractor to follow the plans and specifications. Your Honors, I think that is precisely our case here. They knew of it. They didn't tell us. No expert testimony is required in such a circumstance.
All right, thank you.
Thank you.
Morning, may it please the court. William Rose for the Broadway Electrical. I'd first like to address your question, Justice Gantz. Procedurally, what happened here was the motion for summary judgment filed by the design team was allowed by the judge. The plaintiff immediately filed a notice of appeal. Broadway filed a notice of appeal. Hilton filed a notice of appeal. Both, or all three, Hilton, the plaintiff, and Broadway all filed motions for reconsideration. Those motions were denied. Hilton and Broadway filed immediate appeals after the denial of that motion. The plaintiff settled. The plaintiff settled and released all of her claims against all parties, released her appellate rights, and therefore that supports our contribution claim because we discharged the common liability. We terminated all claims that the plaintiff had against the design team, and the judgment that entered, it's at 1950 and 1951 of the appellate record, it specifically says that the Hilton and Broadway reserve all of their rights of appeal to challenge the order of the court.
But how can you, but you can't reserve her right. I mean, I don't see why reserving your rights of appeal solves the problem that the judgment that is outstanding is that Cambridge 7 and Cosentini are not liable to the plaintiff.
I misspoke. It specifically says express reservation of the opposing party's rights of appeal. So,
But was there some agreement that you were subrogated to her claims?
well, that's what happens when you pay the entire amount of the claim. You assume the right to.
But you usually have a subrogation agreement.
I don't think that's necessary. Under the law, we have a right to pursue our claims for contribution once we discharge the common liability against all defendants.
But you still have the final judgment issued here. So you're saying there can be a final judgment that Cosentini and CSA are not liable, and then a final judgment that they are, or that they're not negligent, and a final judgment that they indeed are negligent and therefore must contribute to the payment of the of the total liability? How can that be?
No, because the judgment that's being appealed, again at 1950 and 1951 of the record, expressly says that the opposing parties retain their rights of appeal. And this was a motion that was not opposed by counsel, at least it wasn't.
So are you suggesting that the plaintiff is one of those opposing parties?
Well, at that point, her claim is settled. She had settled 2 months before.
So she isn't one of the opposing parties, correct?
Well, she was the opposing party on the motions.
Did she assign her claims to the plaintiff, to Broadway and Hilton?
Could she or did she?
Did she?
Not that I'm aware of, but the agreement is at 1920 to 1933. I mean, what's the defendant supposed to do? They have to terminate
Get
all.
an assignment.
They have to terminate all claims, though, in order to discharge the common liability. And once
Sorry, I don't understand that. Could you explain what you mean by
yes,
that?
under 231B, you have to discharge the common liability of all defendants in order to bring a contribution claim. We could have settled with the plaintiff 2 different ways. We could have settled our claims, and she could have pursued the appeal against them, or we could have paid her the entire amount of her claim, and then we pursue contribution.
But couldn't you, couldn't you have done what you did, get an assignment of her appeal?
But what's the difference? We assume her rights once we pay her. We assume the right of contribution. That's what contribution...
Usually it's that you need an agreement to do that.
No,
I mean,
it's statutory. We have the right to pursue our claim of contribution once we pay on their behalf. We've released their liability. She was going to pursue her appeal. She filed a notice of appeal. She filed a notice for motion for reconsideration. She was looking to pursue the claim against them. At that point, we stepped in and paid the entire claim, and then in the judgment from which it's appealed, it's specific. It doesn't say anything about judgment as a matter of law or what the basis is. It could have been on the basis of the settlement, which was filed with the court and approved. If I could make one more point.
I'm sorry, so you're saying that the settlement then essentially negates the judge's finding because it's a settlement and not...
No, it's included within the judge's. The judge finds summary judgment. That's not a final judgment.
Right.
No final judgment entered at that time.
Right.
Okay, but one has now.
Correct, after the settlement, after we discharge the common liability.
But
and
could you
we,
show me where in the statute this issue about common liability comes up? I'm sorry to be so
Sure.
obtuse, but...
Excuse me, Your Honor.
Sure.
It's at Section 3D. Agreed while actions pending against him to discharge the common liability. The very last,
3D?
3D2,
Two.
correct.
Okay.
If I could, I'd just like to
But
point out...
doesn't that simply say that you can't ask them to pay, say, a third or a half when the plaintiff can still go after them for a full judgment?
That's exactly right. That's why we have to pay on their behalf and then pursue the claim against them. We can't, the plaintiff has that right. It's the plaintiff's choice. She can settle with us and pursue her appeal against them, which she had filed notices of appeal for, or she can settle with us for the entire amount, release the claims against them, which she did, with the understanding both with us and the court, the trial court, that we reserve our rights, all the opposing parties' rights, to pursue this appeal. And that's what we did. If I could, just really quickly, I won't quote the provisions, but if you look at sections 2.7.3b, 2.7.7, and 2.7.16 and 17, those are the provisions that require the design team to give notice, to make a representation to Hilton that the work meets the contract documents, and to identify work that's not complete or unacceptable. And 2.7.17 says they have to make sure that they ascertain that the incompleted work or unacceptable work is completed. They didn't do that. They breached the contract. Thank you.
Thank you, sir. All right, we're going to take a brief recess. Thank you.